All right, today's date is Thursday, September 29th, and we have, before us, the case of State of Ohio versus Daniel Bridle. It's case number 21CA0061-M. I'm Judge Tito, so I'll be presiding. To my right is Judge Carr, to my left, Judge Sutton. Each of you will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. It's my understanding you are requesting 3 minutes. Is that correct?
That's correct.
All right. We do have I keep forgetting that we have the time on the TV there, but I'll also remind you if you're getting close. We also have a rule that we would prefer and request that you do not use the names of victims or children during the argument. And keep your voice up, remain at the podium. I can assure you, Judge Carr, Judge Sutton, and I have read the brief, so we are prepared to proceed when you are. Attorney Sweeney.
Good morning, Your Honors. It's a privilege to be here. My name is Tim Sweeney, and I'm here for Dan Bridle, the appellant in this case. And I would like to reserve, if I could, please, 3 minutes for rebuttal. This is a case where my client was faced with some of the most serious charges a man could face, and didn't have an opportunity to defend himself at his trial in front of the Medina County Court. That's a constitutional issue. I want to talk about that first. I also wanted to address today the issue with respect to the other four counts, the intimidation and the pandering counts. And then I'd like to say a little bit at the end about the sentence in this case, the 20 to 29 years. But let's start with the constitutional issue, the right to present a defense. The most fundamental thing that the courts stand for is the ability of a criminal defendant to defend himself and to be able to present a complete defense. This case involved a disputed encounter at the front door of that house on December 5th. Mr. Bridle showed up there, but the issue really for the jury was, why did this happen? What happened here? What made this man a good man with a good history, a good business, to show up at the front door of that house with a gun? He wanted to tell that story. He wanted to talk about what happened, what was going on in his head at that time. His right as an accused person is that he has the ability to do that. And what happened in this case is that the judge, in the pretrial setting, told him and his counsel, Mr. Sheldon, that, yeah, you're going to be allowed to present this evidence. I'm going to allow it all in. I'm going to let in the evidence about the young child who told Bridle about the abuse. I'm going to let in the evidence about the letters, or at least talk about the letters. I'm going to let it all in. This wasn't some short little colloquy. This was a detailed discussion on the record prior to the case, prior to jury selection, in fact.
Counsel, was that at the time when the state had filed a motion in limine?
Yeah, correct, Your Honor. The state filed a motion in limine in February, and this was now right before trial, before they even started picking the jury. And so this was fully fleshed out on the record pre-trial. And the judge said, I'm letting it all in. So, opening statement, Mr. Sheldon gets up and tells the jury what he's going to do, which is going to be, I'm going to talk about these issues. We're going to talk about what was going on with Dan. We're going to talk about what was provoking him at the time, what he was feeling at the time. We're going to try to explain this to you, ladies and gentlemen. And he did that in opening statement. And he made promises. You're going to hear from Ms. Kinsey, the girlfriend. You're going to hear from Dan about this belief in his head that this young girl he loved was being abused by this victim. You're going to hear all of this. That's what the opening statement was. And then so the trial begins. Mr. Victim gets up on the stand and he's asked about all these things. And that's the striking thing about this case, is that the victim was allowed to talk about these issues. The state gets up and asks the victim, what about this young child? Did this happen? What about this? What about the front door? What did you say, blah, 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 when Dan was at the front door with this gun? Did you say this to his face? Oh, no, I didn't say this. He was allowed to address all these issues.
And of course, at that point, though, the motion in limine had been denied, so the state would have to address all that.
That's
at
true.
That point, especially if you have put it in front of the jury in opening statement.
Right, exactly, but that's the unfairness here, exactly. Because then the state refused to accept the ruling on the motion to limit. They never believed the ruling was correct, so they continued to urge the judge, we want you to reconsider this. They did that right before the victim testified. And the judge heard more evidence, and more discussion, and more argument. The judge said, nope, I'm sticking with my ruling. And you know what else she said? She said, and you know what? Mr. Sheldon and his client had the right to rely on my ruling, because I made this ruling pre-trial.
So what you're arguing there, I know you're arguing a constitutional violation, but you're also arguing that it was more than a denial of motion in limine. It was a definitive ruling on an evidentiary issue.
It was, correct. And that's what the judge herself...
Because I think some of it will depend on, was that an actual motion in limine ruling that obviously was subject to revisiting, or a definitive ruling?
Yeah, but in either event, I think, Your Honor, the judge made it clear in that second ruling before the victim testified, this is a definitive ruling, and the defendant had a right to rely on this, and so I'm gonna continue with my ruling from yesterday. I'm letting it all in. And so then the defense gets up, or the state gets up, and they ask the victim about all these things. Okay, so then the trial proceeds. And then it's Bridle's turn to get up. He waives his Fifth Amendment protection. He gets on the witness stand in his case, and now he's trying to tell his side of this. What about these letters? What about this encounter with this young child? What did she say to you that made you feel so enraged? What did the victim say to you at the front door right before you picked up the weapon? All of this was objected to. The court had another colloquy. In fact, what happened here is the court made Bridle go in camera with the prosecutor in the court and give his evidence in camera. Look, the trial does that. I've never seen that before. In camera, after he's already waived his Fifth Amendment, now he's going in and he's telling the court, the prosecutor, here's what I'm going to say. And the court says, well, I'm not going to let you say any of that. Well, you know, this time, that's a complete flip-flop from the ruling that the court had told the defense they were entitled to rely upon. It completely gutted the defense. And so Bridle wasn't allowed to tell his story. And that, Your Honors, is a fundamental denial of his right to a fair trial. This was a case where the jury had to be allowed to decide these issues. I don't imagine, I don't know that I've ever seen a case where the victim, the defendant wants to say, here's what the victim said to me before I picked up this weapon and started firing at his house. Objection. You're not allowed to say that. How can that be? How can that be? After Mr. Bridle has been, you know, going through his rage, because he was in a state of rage. You saw the pictures, you saw the videos. He was definitely in a state of rage. He behaved in a way that you don't expect people to behave. And there's probably some criminal accountability there.
Just quickly, did the court explain the basis for its ruling?
No, well, it really did do a very effective job with their, I believe, a very, it didn't go into that in very great detail. I think the bottom line the court used when she said, I'm going to disallow this, is it's more prejudicial than probative. And that just, at this point in the case, simply wasn't the case anymore. Because the door had already been opened, the evidence had already come in, the victim was allowed to talk about these issues. The state asked the victim, as I mentioned, about these issues. And now it's the defendant's turn. There's really no analysis of prejudice and probative value in a case like this where you can say it's more prejudice than probative. It may be more prejudicial to the victim, but the prejudice inquiry is, what about the person on trial? The person on trial has a right to be heard and to present his defense and to present the evidence he wants to present. And that just wasn't allowed in this case. Let me move, if I could, to the pandering and the intimidation charges, because, Your Honors, those charges simply don't, there's no sufficient proof to establish those charges beyond a reasonable doubt. I believe that's fairly clear on this record. Nothing was obtained. There was no obscene material obtained. Nothing was controlled or possessed. That's a fundamental requirement of that particular offense. We cited I cited in the case the decision of the 12th District, which held precisely that. So there's a real question here about those two, both the intimidation and the pandering counts, being insufficient to survive constitutional scrutiny. they weren't proven. But there's also the issue of the verdict forms. So even if you believe they were proven, the verdict forms in this particular case only permit the lesser of those offenses, which with respect to the pandering account is not an F2, but instead an F4. With respect to the intimidation count, not an F3, but instead an M1. That's a significant difference, and it's certainly a significant difference with respect to the sentence.
Can you talk briefly about complicity and how that factors into those two assignments here, the complicity statute?
Yeah, the complicity statute. I don't think it has anything to do, because even if somebody is alleged to be complicit, there was no underlying offense committed. Complicit one. I mean, maybe is there an attempt? There may be an attempt offense of these types of crimes, which would again be one level down, but he wasn't charged with an attempt offense. He was charged with the principal offense. So there is no complicity. He wasn't charged with attempt. So I don't think that argument, I know the state made that argument, I don't think that flies here. I think there's insufficient evidence on both of those, and the verdict forms defeat those at the level at which he was convicted by this jury. But let's talk, if we could, about the sentence. And I'm going to go out of time. I want to run out of time, because the sentence here is, I think it's shocking. You know, he's a pretty good guy. You know, there were no felony convictions. You know, a good business. He's probably built thousands of homes in this community, employed many, many people, done a lot of good things in his life. And he made this mistake showing up with a gun. It's never a good decision. But, you know, 24 to 29 years. And so you look at this and you say, well, okay, that's the defense the court imposed. Does it survive legal analysis? I don't think it does. I think you had to consider his mitigation. You had to consider the provocation. That wasn't considered here. It's a different issue than, you know, is it provocation for purposes of a lesser offense when you're at the sentencing phase. It uses different language. The question is, was he under strong provocation? How can that not be the case here? And how can this offense, this sentence, be reflective of a court that fairly considered that mitigation a strong provocation? Somebody who was going through what he was going through at that time, the cancer, the caregiver being taken away from him, the belief that the little girl was being abused, the language used with him before he picked up the gun by the victim saying, you know, your girlfriend is blah, blah, and I'm going to do blah, blah, you know, all that stuff. That's provocation that goes to mitigation. It doesn't require a sentence as high as the sentence was.
Obviously, that was part of it.
I'm sorry?
Obviously, that was part of the case, but was it argued by defense counsel?
It was. And the judge said, I sat through the trial, I heard the evidence, but no, this evidence wasn't allowed. You know, am I there? I'm always there. I always say more than I need to. If I could just go a couple more seconds, and it's my rebuttal time, I guess. On the merger issue. You know, this is one gun and one front porch, you know, at the same time. All of these crimes that happened on December 5th should have merged. It's all one thing at one time with one gun. And if you look at the state's theory of the case, I believe the merger law applied to this case requires that conclusion, which means you don't have 3 gun specs, you have 1 gun spec. There was only 1 gun. And then finally, with respect to the issue of even if that argument is put aside for the moment, the most that the court was permitted to do with respect to the gun specs was 2, not 3. And I think the argument there is more of a nuanced one that goes to the statute, but I think the statute on that issue were correct on that issue. So I would like to save the rest of my time for the rebuttal, and I appreciate that.
All right, thank you. You'll have just under 2 minutes. And counsel, you'll have 15 minutes.
Good morning, Your Honors. May it please the Court, I'm Vince Felucci with the Medina County Prosecutor's Office on behalf of the appellee of the state of Ohio. I'll start with the trial court, the argument that the trial court used its discretion when it excluded Bridle's inflammatory, unsubstantiated, and highly prejudicial hearsay evidence accusing his victim, BP, of molesting a child. The trial court made the correct decision on that for several reasons. It certainly did not abuse its discretion. First, let's just start with with the evidentiary rules here, the hearsay rules, LW's alleged statements to Bridle were not excited utterances. There was never a time frame suggested as to when the alleged abuse of LW occurred, and LW was not under the stress or excitement caused by the event. And then, of course, there's the fact that this would be substantially more prejudicial than it would be probative in this case to the state of Ohio to allow something like this to come in. And the idea that this was some kind of a definitive ruling at the very beginning of the case, it was absolutely not, and it was subject to revisiting when the 700 pages of transcript had gone by, and the court had actually heard the case and was able to put all this in context. Of course, it was subject to revisiting. The court could not.
Let's park here for a minute, because this is a very important issue in the case. And as you know, obviously the law and motions and limine and the rules have been changed over the past years as it has evolved. And that is one of the biggest things. Is this a definitive ruling? One of the factors I think you have going against you, isn't it, the fact that it may have been a definitive ruling, was you relied on it as well. You asked questions regarding all this of your witnesses. And I mean the state.
Well, I'm not sure they necessarily relied on it. I think they had to. I think the state of Ohio had to protect itself against the eventuality of potentially Mr. Bridle being able to get up there and say these things later in the trial.
And I guess that's my point. Let me stop you. I'm sorry. I guess that's my point. I'm trying to understand how this all works. If you thought it was subject to being revisited, you still felt that you had to protect yourself as the state. And so you got into some of the content, maybe obviously not as much as he wanted to get into, the defendant wanted to get into, but you asked questions which the jury was able to hear in the responses, specifically as to, for one thing, as to what the victim said when he went to the door. So if you were relying on that ruling, how much more should the defendant have been relying on that ruling? I guess is my point.
Well, I think, so the situation here, defense attorneys get up all the time in opening statements and say, you're going to hear this, you're going to hear this, you're going to hear this. And this person's going to specifically testify, like we had here. Mr. Bridle's going to get up there and testify. Very often, that testimony never comes. And they ultimately make the decision, this person is not going to testify. The trial court here, in making this very preliminary ruling before the trial even started, did not even know if Mr. Bridle was going to testify. He very easily could have exercised, as Mr. Sweeney said, his Fifth Amendment right and not testified at all. So nobody even knew that was going to be the case until he actually got up there.
Well, let me stop you there. Wouldn't it be reasonable to assume he would testify, because otherwise, why would they be opposing the motion in limine? They wanted this evidence, and the only way it could come in was through the defendant, right?
No, I don't think so. There's a huge hearsay issue here, as I just mentioned. If they wanted to bring this evidence in, they should have brought in LW, the person who actually was supposedly made these statements to Mr. Bridle. And they never attempted to do that. Now, that would have been a whole other issue of, is this more prejudicial than probative? And there would have been a whole other analysis of whether that was relevant or whether LW should have been allowed to testify. But certainly, you had a whole other layer here of hearsay that had to be dealt with. And certainly, there was no ruling on the hearsay issue at the very beginning of the trial. That has to be, and that's why it was so helpful for there to actually be this in-camera. What is the actual testimony going to be? I need to hear what you're going to say, and that's the exact words that are going to be said, because I need to know, is that hearsay? And so that's why that in-camera hearing was so necessary.
Well, and obviously we'll go through the record with a fine-tooth comb, but wouldn't that have been discussed in the argument, at least on the motion in limine, and I assume you argued that in a motion in limine, the state did that this was hearsay evidence. So how would this be new for the judge?
Well, I think it was new because again, you didn't know if Mr. Bridle was going to testify. There was there was a girlfriend mentioned that theoretically could have testified. Could have also said this was, that she knew about this through hearsay. There's a lot of variables, a lot of things that could have happened by the time it came to the defendant's case in this matter.
Did they say in opening statement that the jury would hear from the defendant?
Yes. And I think the trial court, as the trial court says on the record, if you look at it, and they're correct, the trial court never said at the beginning of the trial that it was going to let in LW's specific hearsay statements to Bridle.
Now, what did the court say? Did it say, subject to me hearing the evidence, which is often said by trial court judges, I'm going to grant or deny the motions until I hear the evidence? Is that, did they say something like that?
Essentially, the trial court's position was, I'm not going to say anything is excluded at this point. I'm just going to, for purposes now, it's all going to come in, and we're going to kind of go from there. So I think it was implied that this could be would be revisited when the actual evidence came forward, not just some theory about what could be presented at some point.
Are we going to find in the record that the trial court did in fact say that that you were relying on it, the state was relying on that ruling? I mean, and the defense was relying on that ruling? Because I guess this was, kept objecting, and the court said something supposedly about, well, everybody's relied on this ruling now.
As the trial court is objecting to, as we're objecting, the state is objecting to what specifically are you referring to?
Well, what we're talking about here, we're talking about whether these statements, this evidence would come in, the subject, I'm talking about the subject of the motion in limine, I guess is my point. And they're alleging in their brief, and obviously it'll be in record or it won't, that the trial court on the record indicated that this was something that everybody's relying on now, and she wasn't going to look at it again.
No, I don't think it was ever indicated that she wasn't going to look at it again.
And she had relied, that everybody was relying on it. I mean, we're going to read it in the record regardless.
If it's there.
Yeah, if it's there, if it's there.
I don't think that actual word relying was used. I think everybody had to protect themselves as if it was all going to come in, and that's why the state of Ohio had to behave as it did, because it was kind of just left as it's all coming in for now. So.
Well, that was a follow-up question I had, and I'll just make it a simple one. Did the court readdress the motion during the trial?
It was
Readdress its ruling on the motion during the trial?
It was readdressed as was discussed during BP's testimony, in terms of what he was allowed to say about it. And then that's the victim in the case, when he testified during the state's case. And then it didn't come up again until the defense case, when Mr. Bridle testified. Was when it was.
And I think that's one of those two times is the time that Judge Carr is referring to, where he's asking, is the record going to show that the court said, well, I'm going to maintain my ruling because everybody's relied on it.
That's correct, thank you.
So we'll check the record.
Yes.
So, let's just move on to, again, Bridle never stated when exactly the conversation with LW took place in relation to the day he drove to BP's house. It's not a case of sudden passion or fit of rage when Bridle drove over a half hour in the middle of the night out to Hinckley to BP's house with a shotgun after texting somebody that he was specifically going there to murder BP. That's what you see when you look up prior calculation and design in a textbook, Your Honors. So this idea that this was somehow, this hearsay testimony about my victim's a child molester was going to help his case. No, his real objective with this It didn't go to the elements of the case. His objective in this case was to, with this so-called evidence, was to smear his victim's character and attempt to gain sympathy or even nullification from the jury in this case. And that's not a stretch considering what Mr. Bridle did while he was in jail. He basically spent his time there attempting to set up BP, the victim, with child pornography that was not his, in order to smear his victim before trial, so he would show up there and be able to say, oh, he was actually also caught with child pornography, so that's also why I did this. And that, of course, goes to the pandering that I don't have much time left, but I'll try to get to that. And I think that's important. I will say that 12th District Hamrick case, I think is just flat out wrongly decided, Your Honors. And this court should not follow it. It's erroneously decided. This idea that Mr. Bridle had to actually possess the obscene materials to violate that statute, it's just not in there. In the plain language of the statute, possession of the obscene materials is not required. And the problem with 12th District's logic is that it doesn't allow for the possibility that someone like Bridle could offer or agree to deliver or disseminate obscene material by soliciting someone else to do it. And that's where the complicity that Judge Teodosio brought up comes into play here. And the state of Ohio did not have to charge complicity. That's implied in every charge.
But counsel, you have to have an underlying offense to be complicit in something. So, what is the underlying offense? He did request somebody to do this, but nobody complied with that, and there was never any indication that there was any pornographic materials.
Well, and again, there's no possession requirement. It's the language I just stated, the offer or agree to deliver or disseminate obscene material. So you can have an offer, an agreement. You don't have to, that's the crime right there. So, and that's exactly what we had here, is somebody soliciting somebody else to do this. And if the pandering charge stands, the intimidation of a witness charge also stands, Your Honors. And the calumny portion of that statute is specifically is relevant here because by his own words, Bridle's intention was to falsely injure BP's reputation and character. And we know the definition of threat, if you look at the OJI definition, is that the threat can be direct or indirect, as we have here. It does not have to be a direct threat.
Okay, I just want to make sure I understand something. So if somebody just talks to somebody and says, do you have any child pornography? And if you do, will you deliver it to me? That is then pandering.
Can you say that one more time?
Yeah, that's okay. Because I'm trying to deal with this too. What I'm asking is, if somebody were to ask another person, if you have any child pornography, if you have any, would you deliver it to me, please? I'd like to have some.
Yes.
Is that pandering?
I think that is.
Thank you, that's what I need to know. Thank you.
Yes. And just in terms of the few seconds I have left, in terms of the 24 to 29 years, the trial court ultimately sentenced Bridle to far, far less than the maximum sentence he could have received here. Under Reagan-Tokes, Bridle could have been given a minimum of 52 years and a maximum of 70 years in prison if he had been max consect on these. What he got was less than half of what he could have received in this case. And considering what happened in sentencing, he certainly could have gotten more. He stated at one point that he was in the right because according to the Bible, quote, a man has every right to do whatever it takes to prevent an adulterer from invading and destroying his family. He continued with his unfounded claims against BP, calling him a sexual predator and a child molester in sentencing. And the trial court, as was suggested, was not required to address these claims or engage in some kind of debate with Bridle.
Counsel, you have used your time, unfortunately.
Thank you, Your Honors, and I would just ask that the trial court be affirmed. Thank you.
Thank you for your argument. And counsel, we have about 2 minutes left.
And I will do my very best, thank you, Your Honor.
All right.
The record, I think, is pretty clear to the point of the judge saying, yeah, this is something parties can rely on. I'll direct your attention to 332 to 330, I think it's 335 of the transcript. The court goes through this, and this is already, the court had already ruled pre-trial, it's all coming in. Now, before BP gets on the stand, there's another colloquy about it, and it's very extensive. Jury's out, they're going to go over it again, and they're going through it, and they go through all these arguments, every single one of them. Every single one of them he just made, they talked about here. And the court at the end says, I'm letting it all in. I'm letting it all in. And she says, prosecutor continues to resist, saying, and to be fair, I suppose to the defense, technically, this is why I don't like to rule on motions of limiting until I hear how the information is coming in. Because under the rules, a motion in limine is no longer interlocutory. It's a final decision that people can proceed on. She says that. And then she goes on, so technically, if anybody was going to argue that I should not have changed my mind, because she had briefly said, I'm going to have to rethink this, it should have been the defense. But the defense has given me sufficient information that I'm going back to the decision I made yesterday, pre-trial, on the original motion in limine and letting everything in. That was it. That was the rule.
Counsel, the state is making the point, regardless of whether the court made a mistake or not, how have you been prejudiced? In other words, how's your client prejudiced? Because in other words, he did drive a half an hour, nobody's disputing that, he did take a shotgun with him. How is that sudden rage provocation?
Yeah, I think it definitely qualifies, and I think it's one of these issues the jury gets to decide. I think it goes to prior calculation, his defense to prior calculation, which requires something more than just, it's got to be sort of a study. There's recent case law on that, what it means to be prior calculation and design. It goes to that issue. He would have wanted to ask for these lesser offenses of aggravated assault and voluntary manslaughter. He wasn't able to do this because all this evidence was barred. This was an effort to give the jury the human aspect of this case, and he was denied the ability to do that. That was wrong. And this is structural error too. That's our point. The Montgomery case is a recent case out of the Supreme Court of Ohio. It's 2022, Ohio 2211, where the court said very recently of Justice Stewart that if the state puts up the victim as the state's representative in trial, that's structural error. That's really what kind of happened here. This is structural error. And even if it isn't, Your Honor, their burden to show, because it's a constitutional violation, they got to show it's not harmless beyond a reasonable doubt.
I know you're out of time, but what about, you said, well, we could ask for it. I mean, the court could have charged, but the court didn't necessarily have to charge, even with all the evidence coming in. That's still speculative, isn't it?
Please answer that question like you are out of time.
Yeah.
I understand.
But I
just want to make sure I understand the question. The court could have still charged on the
Well,
aggravated.
you were saying, it goes to prior calculation and design, and it really wasn't. It was, provocation or sudden rage or whatever. And I'm saying the lesser included is my point.
Yeah.
And the court still didn't have to charge on that, so isn't that speculation as to whether that you had been able to get a charge to the jury on that? Or a lesser
I don't
included?
think so. I think you would have been entitled to the charge to the jury on that, had the evidence been permitted. Now, there was a fight about that toward the end of the case when the jury instructions were being given. The defendant said, well, now I want that instruction. And of course, well, you waived that because you didn't ask for it before the jury. And the point was, well, I didn't ask for it because you barred all the evidence. I mean, how can I make the sudden rage argument when the evidence about sudden rage has been disallowed? That's a fundamental breakdown in this trial. This was structural error. It was affected the process from beginning to end. Thank you very much for having me ask the court to reverse. Thank you.
Very good. Well, on behalf of Judge Carr and Judge Sutton, I want to thank you both for doing an excellent job arguing this case. It's always wonderful to get good arguments and good briefs. Very interesting case. We'll take the matter under advisement, issue a decision in due course. You both know that the clerk of courts will mail you a copy of the court's opinion on the day it's released, and that the opinions are also posted on the Ohio Supreme Court's website.